If you've been watching my other video about Part 15 of the Employment Standards Act, which deals with termination and severance of employment, you probably stumbled upon the part of the video that talks about the concept of temporary layoffs under the ESA and how you can be considered to be terminated from your job if the layoff exceeds the limits of the ESA. It turns out that this subject deserved its own separate video because of the layers of complexity that the government decided to introduce into this topic. Before we dive in, remember, the ESA doesn't apply to every type of job. Be sure to watch our detailed video explaining which jobs fall outside its protections. Also, this video is for educational purposes only and does not constitute legal advice, and it is not intended to create a solicitor-client relationship. Okay, so what exactly does the law say about temporary layoffs under Ontario's Employment Standards Act? My name is Ryan Keeney, and I'm a lawyer in Ontario. Let's get into it. If you're watching this video and you're currently on or about to be on temporary layoff and your job is regulated by the ESA, you'll probably be curious to know what constitutes a temporary layoff under the ESA, especially since an extended layoff can legally mean you have been terminated from your job. Let's talk about what a temporary layoff means according to subsection 2 of section 56. Okay, there are a few scenarios here. A temporary layoff can last no more than 13 weeks in a 20-week period. However, if the layoff is longer than 13 weeks but less than 35 weeks in a 52-week period, it's still considered temporary if certain conditions are met. But what are those conditions? What does an employer have to give an employee to make sure that this longer layoff is still considered a temporary layoff? Well, a layoff that is longer than 13 weeks but less than 35 weeks in a 52-week period still won't be considered a termination if any of the following things are true. The employee continues to receive substantial payments from the employer continues to make payments for the benefit of the employee under a legitimate retirement or pension plan or a legitimate group or employee insurance plan, the employee receives supplementary unemployment benefits. The employee is employed elsewhere during the layoff and would be entitled to receive supplementary unemployment benefits if that were not so. The employer recalls the employee within the time approved by the Director of Employment Standards at Ontario's Ministry of Labour, or in the case of an employee who is not represented by a trade union, the employer recalls the employee within the time set out in an agreement between the employer and the employee. But we're not out of the woods yet on this temporary layoff stuff. We have to dive into the precise legal definitions of what constitutes a work week and a regular work week and an excluded work week to fully understand the laws that regulate this topic. Subsection 1 of Section 1 of the ESA defines a work week as either one of the following two things. It is a recurring period of 7 consecutive days selected by the employer for the purpose of scheduling work, or if the employer has not selected such a period, then it is considered to be a recurring period of 7 consecutive days beginning on Sunday and ending on Saturday. Now we turn to a slightly different but related definition called a regular work week, which refers to the typical number of hours an employee works each week, assuming they usually work the same amount of hours week after week. This doesn't include any overtime hours they might work. So if an employee normally works 40 hours a week without overtime, then their regular work week is considered to be 40 hours. This term is used to define a standard and consistent work schedule for an employee, excluding any extra hours worked beyond their normal schedule. Moreover, subsection 3 of section 56 says, in the context of a temporary layoff, an excluded week means a week during which, for one or more days, the employee is not able to work, is not available for work, or is subject to a disciplinary suspension, or is not provided with work because of a strike or lockout occurring at their place of employment or elsewhere. Okay, now that we've got those definitions out of the way, let's dive back into subsections 3.1 to 3.6, as well as subsections 4 and 5 of section 56, which we skipped in the other video about terminations, because they are explained in this video. I know I just threw a lot of section numbers at you, but remember that memorizing section numbers is not really what the law is about. It's important to just keep the subject matter in focus. So, as a reminder, section 56 is about what situations constitute a termination of employment, and these subsections that we're going to dive into basically just clarify the complex layers of a temporary layoff situation. Okay, so starting with subsection 3.1, for an employee with a regular work week, keeping in mind the definition I mentioned before, they are considered to be laid off for a week if both of the following two conditions are met. First, they earn less than half their regular weekly wage during that week. And second, the week in question is not an excluded week. Again, keeping in mind the definition I mentioned before, subsection 3.2 states that an excluded week due to strikes, illness, and similar reasons is still counted as part of the total 20-week or 52-week periods for calculating layoffs. Subsection 3.3 states that for employees without a regular work week, a layoff is considered longer than temporary if, for more than 13 weeks in any 20-week period, they earn less than half their average weekly earnings from the preceding 12 weeks. I know that sounds like a mouthful, so I'm going to pause here at subsection 3.3 and give you an example of what this section is trying to say. Imagine an employee, Alex, who works in a job where there isn't a fixed number of hours each week. Some weeks Alex might work 40 hours, others 20 hours, and so on. Over a period of 12 weeks, Alex's weekly earnings vary, and an average weekly earning is calculated based on these 12 weeks. Now, Alex gets laid off. During the layoff, let's say Alex still does some work for the employer or gets paid for a few hours each week, but much less than before. To determine if this layoff is temporary or not, we look at a specific 20-week period during Alex's layoff. If, for more than 13 weeks within this 20-week period, Alex earns less than half of the average weekly earnings calculated from the preceding 12 weeks, then the layoff is no longer considered temporary. For instance, if Alex's average weekly earnings in the 12 weeks before the layoff were $500, the layoff would be considered longer than temporary if Alex earns less than $250 per week for more than 13 weeks out of a 20-week period during the layoff. In simple terms, this subsection is used to determine the point at which a reduction in work and earnings during a layoff is substantial enough to consider the layoff more than just a temporary situation, particularly for those employees whose work hours and earnings aren't consistent each week. Hopefully that example made subsection 3.3 a little bit more clear. Okay, so moving on to subsection 3.4 of section 56, when calculating a layoff period for the purposes of subsection 3.3, the one we just talked about, the following two calculation rules apply. First, don't count excluded weeks towards the 13-week minimum, but do count them in the total 20-week period. And second, if there were excluded weeks in the preceding 12-week period, base the average earnings calculation on the weeks they actually worked. Moving on to subsection 3.5, for a longer layoff period, meaning more than 35 weeks in 52 weeks, the same principles apply, adapted to the longer time frame. Subsection 3.6, similarly, says that the same rules for excluded weeks and average earnings calculation apply for this longer layoff scenario. Subsection 4 states that if an employer lays off an employee without a set recall date, it's not considered a termination unless the layoff exceeds the temporary layoff period, as defined earlier. This means a layoff without a specific end date doesn't immediately equal a job termination. However, subsection 5 of section 56 states that if the layoff does exceed the duration of a temporary layoff and becomes a termination, then the employment is deemed to be terminated from the first day of the layoff. This means, for legal and administrative purposes, the employee's last day of employment is considered to be the first day they were laid off. These explanations simplify the legal language of Section 56, providing a clearer understanding of how layoffs are defined and treated under the Ontario Employment Standards Act, especially in terms of duration, earnings, and the impact on employment status. Okay, referencing back to my other video about terminations, you might have noticed. In that video, when I arrived at Section 63 of the ESA, which talks about what constitutes severance, I skipped over subsection 2 and 2.1 to 2.4 of that section because it involved temporary layoffs, and I said that those subsections would be explained in this video. I'm going to do that now. As a reminder, Section 63 of the ESA deals with what constitutes a severance situation, rather than advanced notice of termination or termination pay. If you are not totally clear on the legal difference between termination pay and severance pay, I recommend going back and watching my video about termination and severance to ensure you get the most benefit out of this video. Okay, so starting with subsection 2 of Section 63, this section just defines what an excluded week is, but you already know what that means by this point in the video, so we're going to skip over that. Subsection 2.1 states that for an employee who usually works a set number of hours each week, meaning a regular work week, they are considered laid off in a particular week if both of the following two conditions are met. First, they earn less than 1/4 of what they would normally earn in a regular work week. And second, the week in question is not an excluded week. Subsection 2.2 of Section 63 says that for the purpose of determining if an employee has been laid off for 35 weeks or more in any 52-week period, excluded weeks are counted as part of the 52-week period. This means that even weeks when the employee was not working for specific reasons count towards the 52-week period. Subsection 2.3 of Section 63 states that if an employee does not have a regular work week, meaning their hours vary from week to week, then they are considered to be laid off for a period of 35 or more more weeks in any 52 consecutive weeks if, for 35 or more of those weeks, they earn less than 1/4 of their average weekly earnings calculated from the 12 weeks preceding the 52-week period. Again, at this point, an example is probably helpful to make sense of all that. So let's pause here at subsection 2.3 to discuss an example. Imagine we have an employee, Jordan, who works in a job where the number of hours they work varies each week. Before the layoff, let's say Jordan worked for 12 weeks, and the weekly earnings during this period fluctuated. First, we calculate Jordan's average weekly earnings over these 12 weeks. For simplicity, let's assume that after adding up the earnings from these weeks and dividing by 12, we find that Jordan's average weekly earnings were $400. Now, Jordan experiences a layoff. During the next 52 weeks, which is the period we're examining for the layoff, we track Jordan's earnings each week. According to subsection 2.3, we need to see if Jordan earns less than 1/4 of their average weekly earnings, $400, for 35 or more weeks within this 52-week period. 1/4 of $400 is $100. Therefore, we check each week to see if Jordan earns less than $100. If, during these 52 weeks, there are 35 or more weeks where Jordan's earnings fall below $100, then this period is not considered a temporary layoff anymore. Instead, it's treated as if Jordan has been laid off for more than a temporary period, which can have implications for employment status and entitlements under the Employment Standards Act. This example shows how the layoff duration and earnings thresholds are applied to an employee with a variable work schedule, highlighting the specific criteria that determine whether a layoff extends beyond a temporary situation. Moving on to subsection 2.4 of section 63, this subsection provides some clarity for interpreting subsection 2.3, the one we just talked about. It says that excluded weeks are not counted towards the 35-week minimum for a layoff, but are included in the total 52-week period. And if there are excluded weeks within the preceding 12-week period used for the average earnings calculation, then the earnings for those excluded weeks are not considered. The average earnings are calculated based on the weeks the employee actually worked. Okay, so that wraps up this video about how temporary layoffs are treated under the ESA. I hope that helps you understand some of the nuances that I discussed in my other video about termination and severance in Ontario. Employment law can be complex, but it's essential for both employers and employees to understand their rights and obligations. If you found this video informative and feel a bit more confident about navigating the world of temporary layoffs, severance, and termination under the Ontario Employment Standards Act, please give it a thumbs up. Your likes really help support the channel and allow me to keep producing content like this. Don't forget to leave any questions, thoughts, or experiences you have in the comments section below. I'm always interested to hear your perspectives and to engage in meaningful discussions. Your comments also help me understand what topics you're interested in for future videos. And if you haven't done so already, please hit that subscribe button and turn on notifications. This way you won't miss out on any upcoming videos where we'll continue to unpack the complexities of employment law in Ontario. I'm Ryan Keeney, and I want to thank you for joining me in this deep dive into employment standards. Remember, staying informed and understanding the legalities in your workplace is key to protecting your rights and interests. So stay curious, stay informed, and I'll see you in the next video. Take care.